I represent Mr. Clark. This is one of his.
This is Timothy Douglas Clark.
Correct, Judge. It was set for a hearing. It's not necessarily a hearing. It's more just a request. Just a bit of a backstory is Mr. Clark was arrested and made bond sometime in 2024. There was an incident in Davidson County where he was arrested for domestic assault, which was subsequently dismissed. But even though it was dismissed, Judge Lockhart Mash revoked his bond, so now he's been sitting without bond. He is severely intellectually disabled and has had many meetings with my own mental evaluator, who I believe has had some difficulty with him being in jail and getting some tests and stuff done. He's now completed his report. There is a facility with which he was staying at where he has a 24-hour guardian with him at all time. It's not necessarily a lockdown facility, but there are people that monitor him and his behavior. I know that there have been lots of issues in the jail, and their issues being that I don't think that they're probably capable of accommodating Mr. Clark the way he ought to be. So we would just ask for a bond. His family's indicated that they will make another bond if we can just get one at all. So we would just ask the court if we can have.
So if I'm understanding, there has been a revocation of this bond by a different judge, Judge Lockhart Mash.
That's correct.
And you're now asking for me to reinstate a bond despite the fact that a different judge has revoked it.
Well, yes, or just give us a bond. We don't have to
reinstate. Or to set a bond.
Yeah, set a bond.
And that bond you're asking for to be set is despite the fact that we're awaiting the results of a competency evaluation.
We should have that in the next couple of weeks.
Let me hear from the state.
My position is going to be the same it's always been. The facility that Mr. Vaughn is speaking of is where he was at when he got arrested. So they don't seem to watch him 24 hours a day. I think they're testified that they don't watch him 24 hours a day, but they do try to facilitate daily activities with him. But it is not a place that the state feels safe enough based on the charges he's facing to ensure that he's not going to get arrested again or come to court.
Well, first and foremost, because the original revocation of the bond occurred in front of Judge Lockhart Mash, the more appropriate person to hear this motion to reinstate bond would be that judge. Wow. Because this court does not typically go behind another judge's order to change the results of that judge's order. And you're asking me, I understand you're asking your client has filed a pro se motion for a bond. The second thing is that we're waiting for the evaluation results. And in my opinion, it would be ill-advised to reinstate a bond until I see what the results of that evaluation are. So,
okay, so we can revisit this once the report is done.
My opinion was we defer the bond request until I hear and see what the evaluation results are.
Fair enough. And for the record, Judge, it is on your docket. It's not just.
That's fine. I don't have a problem with it, and I'll be glad to hear it, but I'm not going to hear it till I see what the results of the evaluation. When we send someone for an evaluation of their competency, that determines whether they're competent to stand trial. If they were found to be incompetent to stand trial, there is a provision under the law for someone to be institutionalized at Middle Tennessee to see whether or not they can be trained to become competent. And I've actually had a case in another county where the training resulted in that defendant being rendered competent to stand trial. So I'm of the opinion that at this point it's premature to reinstate a bond until I see what the results of that competency evaluation are.
Understood, Judge.
So your client's motion to reinstate bond is respectfully deferred until I see those results.
Okay. I'll get with you.
All right. We're now ready on the state versus Billy Lynn Hollis Jr. So you're not working anywhere, is that correct?
Yes, sir.
How long has it been since you worked?
Oh, it's been since I worked a couple months after I had the heart surgery. I applied for Social Security disability. I'm within the top 5 reasons to get disability, the quadruple bypass.
Right now you have no income and you owe $83,000 to Centennial Medical Heart?
Yes, sir.
And that's, I assume, because would you have bypass surgery?
Yes, sir.
When was that?
December 13th of 2024.
All right.
Friday the 13th.
I find Mr. Fox to be indigent at the present time, and I will appoint the public defender to represent him.
Happen if possible, way to form the meeting, that's it, not just a judge.
We're not guilty is entered. When do we want to set him?
This would be General Sylvia's case, Judge, so March would be good.
March 10th? March 10th.
Oh, and Judge, Mr. Fox, one more second. I would also, I spoke to General Sylvie, who had requested, apparently, there's bond conditions for him to stay away from his mother and stepfather's house where the incident occurred. I believe that they have talked to the victim and his mother, and they would like to lift the bond condition that keeps him, prevents him from going over to the house and having lawful contact with them.
So they want to keep those conditions or they want to lift them?
They would like to lift them.
Right.
I believe.
If,
Christ.
I would suggest that there is a written order be prepared for my signature because of the simple
I can do
fact that I think it would need to reflect that.
I can do that.
I just went and buried the dog the other day.
All right, thank you, Judge.
So you work at Dollar General, you make $140. Is that per week?
Yes, sir.
And that's the only income you have?
Yes, sir. I'm trying to get reestablished. I was in jail for a couple of months.
All right, $140 a week. He is indigent. I'll appoint the public defender.
Thank you, Your Honor.
General Sylvia's case of March 10th. Perfect.
March 10th.
Yes, sir.
All right, March 10th. We have not guilty as entered, public defender is appointed. Here you show that you're not working anywhere at all. How long's it been?
Not right now. I was working part-time, but during the winter, we don't pressure wash. It's a job I was working at.
All right, I find Mr. Perry to be indigent. Appoint the public defender.
This yours, Mr. General Stephen?
It is. Could we please do February 10th and Judge Cameron?
All right, February 10th.
Thank you.
All right.
And Jack, State versus Jack H. Sanders Jr. Mr. Sanders, you have income, says you're working somewhere as a Cheatham County Second District Constable, is that correct?
Yes, sir, for the county here.
And. but
That
does
goes with no pay. My only
I was
pay
gonna
comes.
say, it doesn't pay you anything, right?
No,
So you have,
just my social security disability.
and that's $1,639 a month?
Yes, sir.
All right, I find him partially indigent order. He pays a $250 administrative fee. Will appoint the public defender. We're not guilty of this.
This is General Sylvie case as well.
March 10th.
This is Mr. Afris. Is that right? Close enough. He was the one that filed to have an expungement on the break, looked that over. We do believe it would be eligible.
Mr. Willoughby, can I ask you, Mr. Willoughby, can I ask you to sign off on this, please?
Oh, yes, sir.
That's the original. This is the original petition, is it in order? This is the petition, so I have the original order.
This is yours. Easy mistake. I signed this twice.
I've signed your order. You can get a copy of it from the clerk a little later, okay? That was Mr. McAvoy's case, and we had someone standing in for him, and we set it for February the 10th. We were jumping back and forth between the jail and the. Aubrey Whitworth, we need to check on that. Set it for the 18th, and then we find out, maybe I wrote it. I may have written it on my docket differently. Okay, so that would not be Mr. Mossett. What happened to our high school students? They'll get tired. Yeah, they'll come in. What, issue a capital punishment for failure to appear. Mr. Vaughn?
Judge, that would conclude our business with the court. May we be excused? Thank you, Judge. Good to see you.
Hold for here.